My pleasure. So I beg to mention item number 20. In that matter, I was appearing for the appellant. We have already withdrawn the Upalapnama, and the safe fact has been intimated to the client as well as the registry.
In item number 20.
20.
The other side is there.
Other side is no.
So you have already withdrawn your Wakalatnama?
Yes, Lord.
But in that regard, have you
Already intimated the registry.
you sent the notice to the other
Yes.
the client?
Yes. Client as well as the registry.
The registry. You have intimated the registry, it's okay, but have you taken any steps to intimate your
Yes,
client?
yes, Lord.
Appellant?
Yes.
Let me answer.
First one is the registry, and second one is
This one?
yes, yes. Second and third one.
Third is okay. There are contacted counsel for the appellant. The subject that he has got the Wakalatnama. They have got registry. And the appellant is got in that regard. Subject that brief is with you,
Yes, Lord.
still with you.
Yes,
So you want to return it?
yes.
Or how the subject is brief is still with him? And we keep it going to return to the appellant. Accordingly, your name should be deleted.
Yes, Lord. Rest
And
may be direct.
MS J. Boro and
Yes, yeah, my colleague.
colleague.
Lord.
And accordingly, his name. And according to it, delete his name from the Wakalatnama as well as the court doing, along with the advocate MS J. Boro, Mr. D. W. You want to please check out. So, do you have any information that they have engaged any other
No,
company?
Lord. They have not come forward.
Listed 2 weeks. No, 3 weeks. Okay.
With this Lord, with the concern of the other side, I beg to mention item number 19, my Lord. In this case, I have to receive instruction that the case was handled by the earlier counsel, my Lord. Now I have been engaged.
You have been engaged newly?
I've been engaged as a standing counsel of the corporation, my Lord. So I need to go through the brief. 3 weeks time I will grant it. I've been for the other side is here, my Lord.
So you're for the appellant?
Yes, for the appellant, my Lord.
Other side?
In this matter, appearing for the Indian Oil Corporation.
Indian Oil Corporation. You are Mr. K.
M. Smith, my Lord.
M. Smith, standing counsel for the Director of Employees Corporation. And also, how do you are Mr.
W. Rahman on behalf of Mr. A. Sharma.
W. Rahman, Mr. Smith, that stated that he did some research where after 2 weeks,
No, no.
instructed to
Lordship.
as an
May I please, Lordship? Also, item number 24, Lordship. Content matter, Lordship. I am for the petitioner.
Hmm.
But I cannot come in the next week, Lordship.
Pardon?
This matter may come up in the next week, Lordship.
So you are for the contempt, you are for the petitioner or
It is
contempt
not.
petitioner?
It's not. Actually, I am not keeping well, Lordship.
Have you taken consent of the other side?
I'll inform, Lordship.
Ask next week.
Next.
List of market isn't it?
Okay.
May I please? Item number 7.
11,
Item number 7.
7.
My senior advocate is out of station and we have taken consent from the other party. We shall meet adjournment for today.
Your senior is Mr. God.
Yes.
Take a order. Okay. We consider have your
Lordship, I am for the
for
opposite
the
party.
opposite party. You're referring for
Lordship, I have informed them also. Lordship, Mr. D.D. Dekka is appearing for 4 and 5. I have informed them.
you are MS M God.
JC call.
JSK God. No. You are Mr.
V. Chaknaria.
RDMS. We check for the apparent test. I'm your Mr.
DJ Das, your Lordship.
DJ Da. You are for response number 1, 2, and 3.
1, 2, and 3. Lordship.
1, 2, and 3.
And 4 and 5 has been informed, your Lordship. They have no.
MS question a bit represent the conducting council for the conducting council for the after that he also informed the council for the number 4 and 5 list accordingly.
Lordship,
Yes.
after 3 weeks, Lordship. Much okay.
Mr. Lordship, I bring for listing IA Civil number 421 of 2024 in connection with RFA. Lordship finally listed any date.
Bye. Senior make a mention before senior bench. It is the court number 17.
17.
It's 1 second. 7. Make a mention for listing.
May it please your Lordship. Lordship, I beg to mention for listing of IA Civil. Lordship, may it come up on next week any day.
In connection with what?
In connection with, we have filed MSc appeal, but it is not registered. But
Senior bench. Same, you have to make a mention before the senior bench, court number 17.
obliged, Lordship.
So this is second time mail application, Lordship.
Yeah.
Also in this case, Lordship, already 57 days, Lordship. I'm behind the bar. And maybe please 60 days, Lordship. I was arrested on 01/03.
90 days, 395.
50 days.
395.
The case of 90 days, I think it's a 395 matter.
395, 90
And
days.
that apart, earlier it was rejected. So let us call for the case dead. Otherwise, what is your new ground? Any ground? New ground?
Because in this case, Lordship, also the co-accused also getting the bail.
No, whatever. Is there any new ground for you?
The length of
Because
details.
I have, I'm aware about the case
Yes.
because we have disposed of. There are several numbers of accused. In
Yes.
fact,
Yes.
Mr. Pottakur is also aware
Yes.
of. But there are some who are maybe the bona fide departure. There are some other
Yes.
who may be involved. So that is the reason why the
Yeah.
ground of parity cannot be applied for. So let us call for a case diary as soon as possible, as the earliest we are trying.
The same matter is fixed on 29 Lordship.
29.
29 Lordship.
Yes, ma'am.
Okay, then
29.
29. Okay,
Highly obliged, Lordship.
29.
May it please allow. But this matter perhaps will have to be listed before the appropriate bench, my lord. My lord, will see page number 39.
Earlier rejected by Honorable Justice Malik. Only
A.D. Chodor.
Yes, ma'am.
This report of the bench.
On
Any,
30th, ma'am.
you want to pray any date?
30th, my lord.
Date.
Yes. Or 1st of May.
First week of May, any date?
Yes.
3rd of May?
Yes.
No, it will be
No.
it will be there. And 1st of May is is opening day. 1st of May.
Then 2nd of May, ma'am.
2nd.
Second.
Highly ob-
For appropriate time.
highly ob-
May I please, Lordship? Lordship, my senior advocate, Mr. M.A. Hussain, is on log, so kindly the matter may be taken after sometimes.
Earlier rejected by your Lordship, my lord. Page 27.
I'll reject it.
Rejected. CD may be called for.
In that case, it is a second or subsequent bail affair. He may submit, there may be some ground, I don't know.
Yes.
Okay, we have
Lordship, after Sunday. Oblige, ma'am.
May I please? My lord, early sister's diary may be called for, my lord. The diary will require 394 offense, my lord. So diary may be.
Is it also a case wherein the earlier petition was rejected, or
No, my lord.
No, my lord.
out of same affair, most probably other matter?
My lord,
Yes.
out of same affair.
Okay.
One of the petitioners rejected.
He has brought up an
He was Ibrahim. my
On
lord.
my lord, 14th of May, my lord.
14th of May.
14th of May.
Highly obliged.
My lord, case diary not received.
Are they in interim?
Interim.
None appears to call for it. Wait, by the Mr. Board put that issue remind. He has brought up any date.
On my lord, 16th of May, my lord.
The matter will is on 60th of May. Till that, it will. We have received.
Yes, my lord, case diary received.
Lordship, an application under section 438.
Yes.
FIR is in page number 10.
Hmm. petition?
Yes, my lord. My lord, long affair, my lord. Initially, my lord, the accused person, my lord, initially one Mubarak Ali is also friend of the victim, my lord. He knows the weakness of the, my lord, victim. Thereafter, my lord, he along with all other accused kidnapped the, my lord, victim, and thereafter, my lord, all these allegations that, my lord, he took photograph with someone, my lord, with a girl, and thereafter, my lord, on the pretext of, my lord, viraling those photographs. Thereafter, my lord, they also, my lord, made call to his father, my lord, demanded an amount of rupees 3 lakh 60. Initially, my lord, 10 lakhs. Thereafter, my lord, 7 lakh. Thereafter, my lord, his father paid an amount of rupees 3 lakh 60,000, my lord. And my lord, regarding the, my lord, here two accused persons, my lord. One Kalam SK and second is, my lord, Alam Ali. Against Alam Ali, my lord, regarding same type of another two cases already registered in Bongaigaon PS case number 35122, habitual offender, my lord, and Belshore PS case number 3423.
One is Bongaigaon.
Bongaigaon PS case number 35122 under section 420-24, and my lord, Belshore PS case number 34/23 under section 120B, 364A and 368 IPC.
Against one Ali.
Alam Ali, second petitioner, my lord. And after kidnapping the victim, my lord, they, my lord, committed all these offences in the residence of accused number 1, my lord, Kalam SK, my lord, petitioner number 1. There is the gang of,
The
my
girl
lord,
was kept in the house of
Kalam Ali, my lord, petitioner number 1, my lord.
where all these incident had happened.
Yes, incident happened. This is a gang, my lord. There are sufficient incriminating materials against, my lord, Alam Ali, my lord, again other accused persons, my lord. On the basis of the, my lord, after phone pay, my lord, an amount of rupees 60,000 initially transferred. Thereafter, my lord, on the basis of that, my lord, transaction, police has collected the, my lord, bank statement of Alam Ali, and from the bank statement it is
Altogether, her father gave 3 lakh 60,000.
3 lakh 60,000, my lord. 80,000 transferred initially from the phone pay of the victim, my lord, at the place of the incident, my lord, where he was kept, my lord, and kidnapped by the accused person. And thereafter, they made phone call to his father, and thereafter, through one Santi store, my lord, they took an amount of rupees 3 lakhs on being, my lord, intimated by his father. And thereafter, my lord, from the police has also collected the bank statement of this Alam Ali, and it is specifically reflected that on 9/12/23 an amount of rupees, my lord, 80,000 transferred from the phone pay of the present victim, my lord.
Lordship, the Santi store, the owner of the Santi store, he was released on bail on 4/3/2024.
Santi store, owner of the Santi store, is not at all involved, my lord.
Was detained
As per the instruction of the father of the victim, the Santi store, my lord, only paid an amount of rupees 3 lakhs to the accused person.
Mubarak Ali.
Any other subject?
Bank statement, my lord. Statement of the Alam Ali, and statement of the father of the victim is also available.
You are MS Tiwari?
Tiwari.
Are MS Tiwari given? It is submitted by MS Tiwari that the representative petitioners are innocent and they are not brought before the case. Further, it is submitted that the co-accused who alleged on the
Mubarak Ali, Lordship.
Mubarak Ali, he is the Santi store.
No, Lordship, he was also detained in other cases. In this same cases, he was also one of the accused, but he was released on bail.
No, Santi store.
No,
He is the owner of the Santi store.
No, Lordship.
Mubarak Ali is the my lord, who accompanied my lord, the present victim to the
Yes, yes.
place of the incident.
Subject that he co-accused the elder is not paid. And the ground of very the present victim are also are, are, are also maybe granted with the privilege of real estate. Further, the subject that court takes reading cooperate the items important if they're granted with the privilege of real estate. In this context, Mr. Board of Internet Additionally has submitted that there are sufficient implementing measures against both the accused petitions. And the attack incident has happened in the house of the accused petitioner number 1. And 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 he is very much involved in the arrest.
Petitioner number 2, my lord, against him, two other two cases pending. He is the main culprit.
Yes. Further, he submitted that the accused petitioner number 2 is the main culprit of the incident, and against him, 2 more cases. The Bongaigaon case for 1 and Elthorpe case number 4 are also pending for the same set of same similar kind of. More so, it submitted that from the bank statement collected by the IO and the report from the IO, also it seemed that the 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 father of the victim has already given rupees 3,60,000.
No, my lord,
The-
80,000
Huh?
from
80.
from the phone pay of the my lord, present
Phone
victim.
pay 80,000 and
80,000. Yeah. And there are
altogether 3,80,000.
3,60,000 father has victim's father paid, my lord, through Santi store, and my lord, the initial
80,000 to
yes, my lord, 80,000 through
father has already paid. It is 3,60,000. And he rupees 60,000 was also paid to phone pay of the benefit, which is evidently the back statement of the representative is already collected by in connection with this. Mr. Bottom further submitted that the entire the the present 2 accused petitioners along with some others are involved in the alleged offense, and they committed what what the custody required for the and ultimately with the and consequently custody will be required for the purpose of justice provided. The petition stands with
Nine case. 16-17 my lord, same PS case ID not received.
Are you on interim?
No, my lord.
They are not in interim.
CD not received. My lord. CD is pending.
17 case. Same case.
It is still be flying before additional district and session judge.
Yes. My lord.
It's submitted payment report in both the cases. Okay. Submitted payment report that from the notification I can see that the CD of the case CD is still lying before the Lanet District and Session Judge activity number 3.
Delegation the data
To obtain the CD from the that concert board people and submit the report score on the just accordingly we will be make a direction to obtain the CD from the additional
Yes.
so and so and to make it fun.
yes, yes.
So yes, because they are not in interim, I think.
I think one person is there is interim is in favor of one petitioner.
That may be continued.
In respect of the two others, there is no any interim.
Yes, that's what we are saying.
I think if it is
I
possible,
think the seventh of the order to be considered till later. Yes, bottom.
14th of May.
but my prayer was that two person there is no any interim here.
Yes, they are
I'm
not
praying for allowing these two.
No.
But because of that, your lordship is your lordship will withdraw the FIR, your lordship. Whole allegation is against the
Due
FIR.
to some reasons, I think the
But we are the
same prayer for the other
we are the
petitioners were
full members
rejected.
of.
So we are not in a position. So there may be some reasons for which, for that reason, most probably the petitioner, the interim prayer for the other two petitioners were rejected. Interim prayer. That's why we cannot grant that this case without any new subject.
Next date 14.
45.
14.
Interim to grant till 17 of the payment.
Lordship, then it will be 115, your lordship. 115.
15. Do you have any option?
No.
Okay. 15.
Please, your lordship. Lordship, we finally separate for enhancement, lordship. Enhancement and another point is, lordship, the liability of 50% has been imposed against the motorcycle, lordship, which is not actually, lordship, proper reason because that motorcycle was the victim motorcycle. The only lordship stated that we have not made party of the motorcycle, so 50% liability has been imposed to the victim motorcycle because the motorcycle of the victim, he was the owner by himself, lordship. So we have clearly mentioned in our claim petition that at the time of accident, the victim person was driving a motorcycle and he was the owner. So question does not arise to make party of the motorcycle, and there is no any contradictory evidence of the other side also that the motorcycle is liable because one truck hit the motorcycle from the back side, and Police also filed charge sheet against the truck also, and we have produced the PW to eyewitness that due to fault of the truck, action was occurred. But the learned member of the MSCT Guwahati Lordship only taking the plea that in the accident motorcycle was involved, so 50% liability against the victim vehicle Lordship. That is the main Lordship ground of our appeal, Lordship.
It has already been received.
Already LCR has been received, Lordship.
So you are appearing for one?
I am for one, Lordship, on behalf of my senior.
1 and 2.
One only.
Only one.
Yes, Lord. Insurance company.
Already notice has been served, Lordship, on the last order. Also, all opposite party was appeared, Lordship. Opposite party number 2 appeared, 5 local. Now in opposite number 3, Lordship, notice was served, Lordship.
You are appearing for Mr.
DK Koli.
Mr. RC Paul.
RC Paul. Your good name?
Ayarda.
Ayarda.
Yes.
Also artist Ayarda. RC Paul. Office note dated 4/2019 note reveals that the service of respondent number 12 as well has already considered some for the application for hearing, and this accordingly the matter will be listed for hearing on. It will be listed for final hearing.
Yes,
We have
sir.
already admitted.
Yes, Lordship. Kindly give the date, Lordship. Already LCR has been received. If it is possible, Lordship, kindly give one date, Lordship. Native prefer.
28/5.
Most obliged, Lordship.
Appeal by the claimant for enhancement, Lordship. Income has not been considered as shown in evidence on record, Lordship. That is the only ground. Lordship may admit this appeal, and Lordship, she is appearing for respondent number
1.
1.
Sorry, 3.
3, Lordship.
And what about 1 and 2?
1 and 2, we have to issue notice again, Lordship. In delay condonation petition, we have issued notice, delay was condoned, and thereafter, Lordship, appeal has been come. So I will take steps on respondent number 1 and 2. Okay, definitely.
No.
I'll survey extra copy to her also.
Council for the you got 3.
3.
Let's get to it. Issue note and also copy. After court,
Obliged.
I'll apply.
you serve a copy. Yeah, you have
Lordship, I'll serve.
No, he'll give 2 o'clock.
Next video, Lordship. Lordship, matter may be listed on second week of May, my lord, or showing the name of all the respondents are GS, my lord, represent. Earlier, my lord, the miscos order passed by this honorable court, my lord. Dispose of this miscos, my lord.
What is it? This is IMC.
My lord.
What your submission? I couldn't follow.
My lord, matter may be listed on the second week of May, my lord, and showing the name of GS, my lord, for
GS,
my lord, for the all the respondents, my lord.
How can you say for all the respondents? They have already appeared. Mr. Gogoi, he is here only. Item number 8. The name of Deputy SDI is showing, she is insisting that
Lordship.
most probably government of Assam also took it.
Lordship. Our name should be reflected in the court. Yes, I mean.
15.
At Heard Ms. L. Vandita, United also for the effort. The name of only the name of the committed to the about the stop the Google the United the name of the committed to the GM and this is according to the to reflect the name of GS accordingly after 2 weeks.
My lord, any date may be fixed, my lord.
In May, second week of
my
May.
lord, my lord. If possible, my lord, 14, my lord.
14th of May. Okay. We have not 30 in our petition, we'll guide.
Lord.
Oblige, your lord.
Please.
May please your lordship. Lordship, this appeal has filed for modified a judgment, lordship. In earlier occasion, court has directed to file affidavit why further amount has required, lordship. Lordship, I have not filed affidavit, so 2 weeks.
Where is the order when you are directed?
Lordship,
which order you were directed?
Order dated 17/11, lordship, 23. Some difficulties I could not file the affidavit, lordship. So 2 weeks.
You are for the appellant?
Yes, lordship.
You are paying for the respondent?
Respondent, lord.
2 weeks time may be granted, lordship.
You are MS J. Khalid?
J. Khalid.
Heard MS J. Khalid for the appellant. And also heard MS
RDB. RDB.
RDB. The deputy is there?
Lord.
Deputy.
No, lord. PGC, lord.
Or deputy. For the respondent. It is submitted by MS Khalida that some personal convenience the appellant could not file the additional affidavit as asked by the as directed by the court by order dated 17/11. According to the some more and application by the attorney. It's accordingly you are 2 weeks, 1 week, 2 weeks, 2 weeks. This addition here will be listed with the addition hearing for.
Yes, lordship. Yes, lordship.
By the time you file it.
Yes, lordship. In item number 10 also, lordship, same order may be passed, lordship. Order dated earlier order dated 17/11, lordship.
They are also 17/11.
Yes, lordship. They are also 17/11.
They are also you are appealing. Okay. Okay. We'll
Appellant is different, lordship.
Yes. Appellant may be different. The order is same.
Yes, sir. Oblige.
May it please your lordship. This is a statutory appeal against the judgment passed on 13/9/2018. So lordship may admit this appeal.
On last listed on 22nd of this month.
Yes, that day Mr. J. Ahmed said they will be filing some objection. They haven't filed anything, lordship. Monday it had come, lordship, if lordship remembers, because we haven't filed any petition.
My lord, appellant position.
Huh?
Appellant position.
No, we are not repeating here. Just from your submission most probably
Yes,
still not.
My lord, we are going to today we are going to file Bakizai case, my lord, for recovery of the amount. You will also admit and we have no objection. Today we are going to file
Today he is understanding what is
No, I am already understanding, but it is not there, my lord. Since a award has been passed, my lord, it is the duty. It is not they should make the payment. For long period, they not make the payment. Appeal is there. Let ABIT admit that if they file in next day petition, then they will object. And in the meantime, we will today going to file Bakizai proceeding with. Then necessarily they will come for stay.
Then only they will not.
They are the poor people, my lord.
Yes,
That is
let
why
the
they are not
natural
that there.
course follow, Lordship.
Then if they that come, then should not be stayed or let they get some punishment there.
Council for the property. Yes, Mr. K. For the is submitted by for why you have filed against
Lordship, Lordship, there was no DL. Then the amount of there was head-on collision between two vehicles. So the court has not apportioned, and the income taken is not correct. And those are the main grounds, Lordship. And future prospect income in that they have.
along with other so he is the sole respondent. Are there any other respondents?
One and two. For three, Lordship, we will take step by Dusty.
But,
he is the owner driver of the
so
vehicle.
far as IA is concerned, my lord, IA, it will be heard at the time of hearing of the appeal, because whether it is maintainable or not, those things are come.
Will come definitely.
But notice can go, Lordship. I'm
No,
not asking
yes.
Lordship to,
Three-
but
three
we
notices.
have given in the I also notice can go, Lordship. In,
So I will want to I will let the three.
I one for I didn't mean a bit. It a bit for or for why you need the justice a bit in
no, because Lordship, he is not appearing. This owner driver, since we are taking the plea that he did not have a driving license, he is the owner driver. It is not a question of driver and owner. The same person, Lordship. So he did not appear in the delay also.
Council for okay, you have justice for it.
Yes, Lordship. And IA number, Lordship, if he wants to know, 3034 of 23.
Yes, they are also we are issuing notice.
Yes.
No. Main appeal is the and
Note in I Lordship, note to only 3 because we have already served them the.
I also you want testimony?
That's it. Yes.
1 and 2.
My lord, in this case, I remember long period of delay. We have not make any objection. We allowed.
And delay.
Yes, long period. But we have considered yes, it may be allowed.
So this time they will accommodate you. Yes, Mozumdar?
Long to Kiman long money is always relative. Long is always a relative term.
He accommodated that time, so this time you will accommodate him.
I'll accommodate. Lordship, we are insurance company. We can no problem.
Yes, sir.
12. Lordship, this is a RFA regular first appeal, statutory appeal again, Lordship. And in this, Lordship, I have the IA also 1212. There we can deposit 50%, Lordship, of the decretal amount.
Order later on, let this issue notice first. I will be on linked with you. I. Yes.
But since it is a decree, Lordship, RFA, it is a decree we are coming against. So, no problem.
Next update their listing will consider.
Yes. Lordship can admit and in that.
Yes, appellant. So, again. Is that appeal under section 696 of anti-6 CPC against the judgment indicated 524 as well as Senior Division Number 1, Kamrup and Guwahati in Manisut 75, Manisut number 75 of 2015, declaring this book filed by the plaintiff that the particular perspective and also take the subject made by the judge happy with that issue notice to the respondent. You take step, and we are also calling for the LCF to make
Yes.
step.
I'll oblige you. In the IA also we will take.
I want to take steps.
I wanted stay, Lordship.
Okay, this time we are going to issue notice on the I also.
I also. I'll oblige.
May it please your Lordship. Lordship, kindly this matter may be adjourned for the day. It may be taken up on the 1st of May.
Your Lordship, my name has not been reflected in the cause list in spite of specific order in the delay application. So, the registry should be, in the delay application, it was specific order that my name may be reflected while listing it for admission. In spite of that, my name has not been listed. So, today I will take a copy of the appeal. So, it may be listed on 1st of May. Your Lordship.
You are MS
MSec, your Lordship.
MSec. Heard MS MSec. And also heard Mr. T. Mandal.
1, 2, 3.
Respondent number 1, 2, 3. Now the subject Mr. Mandal, that in spite of specific direction in IA civil number
2035.
2023, his name has not been reflected in the court by the context. It is directed to reflect the name of Mr. Mandal for the respondent. So it's list accordingly after 1st of May. You want?
1st of May.
1st of May.
Highly obliged.
May I please, Your Honor? I am appearing for the respondent. Your Honor, may peruse the order dated 26/9/2023.
Order of who?
Order of this Honorable Court.
At the record is there. It is the I. 20? You have said 20?
Item 26/9/2023.
26.
In the main case.
In the main case. This is I only. This is I. Oh, we are on 18. We are on 18. 18 is MF. If we go to you are on 18, MFA 153. Some material file. Just for information. Yes.
If I may, my lord, the I is for delay in setting aside abatement.
I which I which number?
My lord, IA number
351.
351. Yes, ma'am. My lord, the IA was filed by the appellant. The appellant had died.
Huh?
My lord, the appellant had died. Subsequently, this IA was filed.
By the appellant.
Yes.
This I is for substitution or what?
Yes, my lord, legal aid. My lord, this application is for setting aside delay, my lord.
Delay in
condoning the delay of
in filing this substitution.
Yes, ma'am. Yes.
They depend upon it's Sophia Rocket Graki they she was there, I think. Oh, I like it. It's okay. And there are other eyes are also there
Yes,
connected with this.
Yes, ma'am.
Okay, with is it not applicable for but you are Mr.
G Imtiaz, ma'am.
He Imtiaz appearing on behalf of Jet Mukit.
Yes, ma'am.
On behalf of Jet Mukit. List according. It will be listed after 2 status.
Yes, ma'am. Highly appreciate.
Lordship, my payroll was ordered at 26/9/23.
369.
26.
Yes.
This honorable court was pleased to call for the original record of the case of the NWC case number from the commission, as the LCR which was received was not in a original file, that was a duplicate file.
Thereafter, any requisition.
A report
Order was
from the-
passed on 26/9/2023, directing the commissioner employees to the original request record. But in
A report has been received, Lordship. I have perused the case record.
as per you, what is the report?
There is no original file
Acha.
record in the.
Do you have any copy? Because it is incomplete record.
No, Lordship. We also do not have any copy. And the exhibits are also not complete.
This appeal is of 2003. he will pass necessary order. Because this is not the way. They do not. They have not maintained any case record. And the earlier where the exhibit the documents were exhibit. So this is the only record we have received.
Lordship.
No record ko nahi.
No.
This is the only record. Oh my God. You have to equate nothing there. Only the some photocopy, scan copy record on nothing. Not here. No, neither the exhibits. No, nothing is there. How case it is? 2003 match. Pass the order. We will pass the order. Now at present we are listing it after 2 weeks. I will pass the order.
Lordship. Obliged, Lordship.
You could take it order. Pass.
My pleasure, Lordship. Regarding respondent number 2, service is complete.
Respondent number 2.
2. As per order dated 22/5/23, my lord.
As per order dated
22/5/23. My lord, regarding respondent number 1, as per office note dated 22/11/23, service report has arrived, where it was mentioned that there was no such respondent was found in that village as per village headman. Kindly, we will take steps to document.
Do you have the proper address of the respondent? Because from the headman or the village headman is the report.
Not that.
He is not there. Any other alternative address do you have?
Alternative address is not there, but still, through Dusty, if insurance can help us.
That's happy. The notice number that was served, but as per office noted 11/2020, the service report returned with the report that the notice is returned with the report is not found, and the village headman also does not know that the person it is for this subject. According to the one to the okay, we are allowing the justice service. Will be see this time will try.
Only upon respondent number 1, my lord.
Yes, only on the
Obliged.
yes, sir.
In this case, my lord, I am appearing for respondent number 3, Oriental Insurance.
May I please, Lordship? Lord, I have filed this IF for continuation of delay, man.
How many days did you
118 days.
118.
118.
118. 118, my lord.
118.
Yes.
You are 43 and
3 minutes.
1 2. Is there any service report? Not yet arrived. And do you have any objection in the 118 delay?
No, my lord.
In which para you have mentioned about
My lord,
your
para number 4, my
grounds?
lord.
Para
Para number 4, my lord.
para number 4.
Yes, my lord.
You are Mr. Emda. You are Mr. Emda.
Yes, yes, Mr. Lammal.
Yes. Are Mr. Emda applicant? Yes, applicant. Not part. Office from the office note. 9:10 to 10. Neither the answer nor the AD card is returned issued on behalf of the customer. Next, the application and the box for contributing 1183 in filing the connected appeal against the judgment and award which is 55 alphabetical box company. It is subject it's not that the present applicant as applicant to the purpose and the not even managed to put for filing for filing it and how we put after some complete of activity and according to file if there was a delay of one day in preparing the appeal for the there is no such or part of the application for the could not approach it or by a bit in that more people it of the and the ground met better number 4 is on video 150 very connected in respect about this report this report connected the text this order verify with the above step. Okay, your eyes can dispose it will be numbered based.
My lord, I have a submission. As they have taken steps in the year 2021, long back. After that, they have neither taken steps. So regarding that part, that interest part may be interest on the amount may be forego.
We have not registered it, but let us file and
apply.
You may make submission.
My lord.
May I please be my lord? This close objection has come first time lordship, so I'll stop the copy and maybe take with the main appeal lordship. No, no, no.
25 को
25 अपनी से नहीं
क्वेश्चन नंबर 22
Yes, can be taken.
Lordship, as per instruction of my senior, we will file an objection in this case. So
I'll serve the copy, Lordship.
May we serve, Lordship? In the meantime,
let it be listed after 4 weeks and I'll serve the copy in the meantime. Because earlier lawyer I have served the copy, he expired, Lord.
So they are the newly appointed lawyer. I'll sub the copy.
Sub the copy of what?
Copy of the cross subject.
Cross subject.
And it may be hard at the time of hearing of the mail.
That will list the matter accordingly. Sub the copy. It will be listed after 2 weeks. Sub the copy in by that time.
After
Will
4 weeks, Lord. After 4 weeks.
Not a matter of 2010, not after 4 weeks.
Full Lord, 2 weeks.
After 2 weeks.
May it visit the Lordship. Lordship will peruse office note dated 6/12/23, Lordship. The LCR is received, but for respondent 3, neither AD card nor unserved notice have been received. Lordship, it can be deemed served because in the delay petition also earlier on 23/11/22, it was deemed served. So, because we have taken the step last year itself.
So who is he?
He is the owner of the vehicle, Lordship.
Owner.
But we are alleging the main thing against the claimants because we are alleging fraud in this case, that they were not involved in the accident. So main people are 1 and 2, and they are represented, Lordship. One counsel is appearing for.
Okay, if we just collect the consignment report and submit before us.
Yes.
On the next week, we'll give you a short date.
Fine,
Within
Lord.
After 1 week.
Fine, Lord.
RDMS, RD, done it for the and it is submitted. It is in that the service got be completed on number 1. However, as per office note dated 6/12/2020, neither the AD card nor the other that contact the order list accordingly after 1 week. Do you want any date or after 1 week?
After 1.
After 1 week. Okay, good.
I'll apply for it.
What are the is it?
But I am saying I was on like in another program. Another the second bill application at this my lord, may I pay for call for the CD, my lord?
That's what actually we supposed to pass the order, but with your temper from
My lord.
I thought that they have
My lord,
been so this is a second bill application.
My lord.
Mobile. So let us call for it.
My lord. It's from Gorong district, my lord.
It's from Gorong district.
My lord.
21/5.
Hello.
I is for delay in filing registration petition.
This is, one is for restoration, one is for delay.
Yes. I is for delay, NC is for restoration.
One, what is the delay? 98 days. I8 is what? I8 is 5. You are Mr. T. Roy?
T. Roy.
Mr. T. Roy, you run it also for the then application 5 rate reflecting constitution for contradiction of the 8 days in filing the restoration of RFA number 47 10 which was 44 it will be it. Okay, you take it.
Yeah, please, Your Lordship. Lordship, the service with regards to steps has been completed. The matter may be fixed for hearing.
So you are appealing for
For
one?
all the response.
All the
Yes.
LCR you will see.
We have filed all the relevant documents along with the appeal.
Otherwise, application the record will be also very valuable to the voluminous. RMS.
V. Rai.
You are Mr. P.
V. Rai.
V. Rai. RMS V. Rai. For the application also heard. This time your name is here?
My Lord G. Imtiaz, appearing.
Here only.
Yes, ma'am.
Heard. All respond.
Yes.
All. That's it. See that. Also submitted by the patent officer. Hereby all the hereby all the was earlier not admitted or
no?
And it can be admitted for fact hearing can be
yes.
For on after 3 weeks.
A date may be fixed.
35.
Highly agreed.
May it please your Lordship. Lordship, we have filed the affidavit regarding dusty service upon respondent number 2. But as per the investigation report, Lordship, respondent number 2 could not be traced out. He has visited his residence.
Then how?
Lordship, some time may be granted so that we can find out the address of respondent number 2, Lordship, because
where from you are saying that he shifted his address?
as per investigation report, Lordship, in the affidavit, page 17.
Oh. He is respondent number 2.
2, Lordship.
So you are paying for one?
Respondent number.
From office note dated 23/2024 said that it will be debited back after taking steps to respondent number 3 to the report. But from the inquiry report, it is said that the report is not that she shifted her address.
No. She could not be traced.
Could not be traced.
He went many times there.
As she could not be traced out in spite of and if the resident was found lock, 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 was under lock and key. In this context, some given to allege her property afresh against it. List accordingly after 1-2 weeks.
4 weeks.
4 weeks.
Apply search.
May I please, Your Lordship? As per office note dated 27 to 24, Lordship, service complete, Lordship, but LCR not received, Lordship.
Service is already completed. You
Yes,
have
sir.
appeared for 1 and 2.
1 and 2.
LCA was actually not called for till now.
LCR may be called for, Lordship.
Yes, we are calling for the LCA.
Yes, sir.
Though it was admitted that LCA was not called.
Yes, sir.
Heard your Mr.
T. Sharma.
Heard Mr. P. Sharma. Not with appearing for the not heard.
Yes, sir. For 1 and 2.
That's
All that.
not with appearing for does it is that the already complete for the respondent. However, the LCA is not call for the LCA. It will to the input. The matter will be listed for hearing. So it will be listed for hearing after receipt of the LCA.
Yes, sir.
Listed.
Good.
Lordship, in this matter, we are appearing for the plaintiff respondent number 1 to 5. 1 to 5. 6, 7, and 8, Your Lordship, they are the performer here. The main fight is, Your Lordship, in between the plaintiff and the present appellant, different number 1, Your Lordship. So the trial court granted, Your Lordship, an injunction under Order 39, Rule 1 and 2 on being remanded by this honorable court. So they have challenged this order here, Your Lordship, and they have got a stay order also, and the appeal has been admitted also. Matter is very urgent, Your Lordship. The matter
So
is
now
very
he is
urgent
saying
in
that
this
he is
case.
already appearing for 1 to 5. And 6, 7,
They are
by his
performer.
submission, these are their performer.
So they may be stuck off, Your Lordship, and matter may be fixed for hearing.
Yes.
Yes. Your Honor, earlier we are appearing on behalf of appellant. Now the client has taken the brief from our. So, therefore withdraw already this. They get back on 5 April 2024.
Order আমাদের dismiss হয়নি।
So as per your information, whether they have engaged any other counsel? No. Do you have any information?
Yes, Mr. Senior Counsel, Mr. Sahewala would be appearing.
Oh,
We
Mr.
have
Sahewala will be appearing.
Yes, my lord. Today morning we have received the telephonic instruction.
So till now we have not filed any pakala.
No, my lord. Today morning just we received the invitation.
Your Lordship, our limited prayer is, Your Lordship, 6, 7, and 8, Your Lordship, they may be stuck off, Your Lordship. And the matter may be
I
fixed,
can
Your Lordship.
understand that
Matter
your
may be,
prayer, but let him say on the next week if
they are not necessary
they are
parties,
not
Your
necessary party, we can stack up. But let us say
Your Lordship,
we
in
have
the,
any instructions?
No, my lord.
no, matter may be fixed for hearing in the second week of May, Your Lordship. We are not on the, they will contest, Your Lordship, they will fight it. But they will have the chance of
Now,
hearing.
regarding the tracking out the name of the respondent number 6, 7, and 8,
6, 7, and
we'll
8.
do one thing. As they have engaged newly, we'll just fix a date after 1 week. We'll fix a date. On that day, if as per your submission, if they are also ready to stack up the name of 6, 7, and 8.
Lord.
It will be struck off and then definitely it will be listed for hearing.
Then that make me fix your law.
We are going to fix it. Considering your submission, if it is an urgent matter, then we are going.
Lordship, kindly the name of the cause is please struck off from the our name.
So you are Mr.
I have C. Talukar.
C. Talukar.
Here,
Appearing on behalf of
S. Sharma, Z. Deka, T.K. Bhuya, all are.
আরে সিহঁতে এটা ফেভাৰেবল অৰ্ডাৰ পাই আছে তোমাক দিলে কৰিব কিন্তু তুমি আগতে লিষ্ট কৰাব তোমালোকে বহি আছা
accordingly the
এটা অটোমেটিক্যালি হৈছে
also receive back their file. Receive back the brief of the
তোমালোকৰ পাৰ্টটো তোমালোকে ভাল
contact Mr.
H.K. Sharma.
H.K. Sharma to submitted that they have already clear the duty and discount that they advocate will be verified. Mr. S. Ali, the learned counsel for the respondent, submitted it and he has already appeared on behalf of the main respondent 1, 5, and as he submitted that 6, 7, and 8 are the pro forma response and their name if it's strike on and later may be listed for the Mr. Sharma that as they have duty and some sort of action and accord to the matter after 1 week of set apart people did it. We are listing it on 10/5.
Let's say 10th
of May.
May.
And then the 10th of May, we hear the other side, and if it is possible, then we'll
My
start
learned
name.
friend submission may be recorded so much that JN Sayola has been
Yes, I have already recorded. Okay. Your name should be recorded. Okay. It is also submitted by so and so that the names of the under active counsel may be deleted from the call list. Which we will stand.
Deeply
Yeah, please, your Lordship, this IA is for condonation of delay of 85 days in presenting the connected appeal. Lordship,
85 days delay.
85 days. Lordship, the notice upon respondent number 2 is complete and notice of respondent number 1 is served through paper publication. Lordship, kindly grant 2 weeks time for filing the appeal affidavit.
So you have already served the notice to a paper.
Yes.
Steps has been taken.
Yes.
You are Mr.
B. Kumar.
Heard Mr. B. Kumar, the learned counsel for the applicant. Also heard.
R.D. Mujumdar for respondent.
You are here. Also heard R.D. Mujumdar. It is submitted by Mr. Kumar that they have already taken for issuing notice under respond number 1 to paper publication. However, they need some more time to file. They are allowed this accordingly. After 2 weeks, you will do. After 2 for filing by the
Aliam.
Little intelligence regarding item number 30. Item number 30, little intelligence. We will file our detailed objection on this. I forgot to mention.
In item number 30.
I will file our written objection. I forgot to mention that. You will have to call the LCR.
It will be most probably after receipt of LCR. So you want to file objection.
Yeah.
may be recorded.
30 submission. You are appearing for response number 1
1
and 2. 1 and 2 after that. That you will file it.
I love it. My lord, in item number 31, my lord, in the IA there was an interim. Because of this change of counsel, my lord. Item 31, my lord. Just now, my lord has passed the order regarding change of counsels, my lord. In the IA, my lord, there is an interim, it may be continued.
31 in IA 2462.
My lord.
IA 2462 interim because
Much of that.
so what is this number? 30? $39
33. My lord, in this case, as per Office Note 6,
I is for what?
delay, my lord. 86 days. We will take fresh steps through Dusty, my lord.
Both 1 and 2.
My lord.
Part of the submitted for the applicant and it's submitted that as part of its notice.
6/12/23.
That services the identity not answer notice by the district for that the applicant will take steps and the service just service according to the for service of notice on telephone number 1. There
Apply.
This report.
Next is your lordship. Lordship will peruse office note dated 13/12/23. Lordship. Respondent number 2 has filed wakalatnama, and for one process server report has come that no such person is there. So lordship, I do not know. He is the claimant petitioner. He was the claimant petitioner. Lordship will make newspaper publication. So at least the delay the case can proceed. Lordship further. So for respondent number 1, there are only 2 respondents.
1 is
Here. 2 has filed wakalatnama.
one is the claimant. And 2 is the
Owner. It is from WC cases, EC cases. So only 2 persons.
so he is not available.
No such
Person is found.
no such person is found, and there is a witness signature also in the report. That's what is written.
As per office services and the conflict has already for filing for number. But the service is not yet completed as per the report of the process server. But not found at and no one no after no one from his professor could not say this bad context. Pray for pray for public publicity and pray to not be the phone number 1. There enough to notice upon the phone number. One particular English you can
Lordship, only one paper will do because as per CPC, one vernacular action is Nagaon from Nagaon because they are from Nagaon.
No. one particular widely complicated case now up. And sub-
Not 4 weeks, Lordship. Later than that, because we'll have to file an affidavit also.
So
6 weeks, Lordship. 6 weeks. And Lordship may give a date of appearance, because in the newspaper we have to mention the date of appearance. After 6 weeks, Lordship can give a date.
10th.
Highly obliged.
Maybe I am from the police. In this case, student number 2 and 3 died. So we have filed an IA Milord. That is IA is numbered as Milord 165623, and notice was issued Milord on 24/7/2023, but it is not served. And again, another person Milord also died Milord. So there is we have filed another IA Milord. So my prayer Milord in this IA number 165623 and IA number Milord. IAC number 4524. In both cases, notice may be issued again. There are 2 sets of Milord.
No, I 1656 is for
Is for Milord condemnation of delay.
Condemnation.
81 days. And notice was issued on Milord. That was Milord date Milord 24/7/23. But that is unserved till date. So I may be allowed to take fresh step. And Milord IA number
For whom? For 3.
Is for 2 and 3 Milord.
2 and 3.
Yes,
You
Milord, 2
already
and
you have appeared for
My
him?
lord, I am preparing on behalf of Mr. Jackson. He is out of station.
No, for whom? Which
For my
one?
lord, respondent number 1, 5 to 13. As per my instruction.
1,
1, 5 to 13.
and as per your submission, 2 and 3 is unserved.
2, 3 and 4.
2, 3 and 4 are unserved.
After they have expired Milord, so we have filed substitute petition with condemnation petition Milord.
3 and 4.
2. Kindly see Milord IA number 1656, first Milord.
4 is also died.
But so she died subsequently Milord, so we have filed subsequently Milord. Yes Milord.
Okay, then 4 died. But the question is that 1 and 2 and 3 are not served.
Not served. Notice issued. So Milord, we may be allowed to take fresh step for
And for 4, you have already filed yet another substitution petition.
another set Milord. So on that Milord, notice may go. Notice are issued.
You are Mr. M. Ali?
I'm A. Rashid.
Huh?
A. Rashid.
A. Ali.
A. Rashid. I have come subsequently.
A. Rashid. What?
My name reflected.
Yes, sir. Heard Mr. A. Rashid. And also heard Mr. You are Mr.
A. Hussain.
A. Hussain.
On behalf of
Appearing-
Mr. Z. Hussain.
Appearing on behalf of Mr. Jet for respondent number 1, 5
13.
to 30. Mr. Rashid, we done it for the but it submitted that the service is not yet completed on the claim number 20, and he may be allowed to take fresh steps on the during the pendency of the case. We have got the information that the respondent number 4 or 5, and for which a separate IA has been filed, being numbered 1044.
No.
1074.
No. There is a IA number 4524.
This is the IA for 4.
Well, yes.
Already filed
There
an
are
IA.
2 sets of petition. One abatement, one delay on the substitution. So three petition, for you.
This is for confirmation. So why don't you file the for restoration of the substitution for the against the respondent number 4?
Now
While
she
the other one?
Now other one notice is issued, notice not served yet. So I am praying for issuing taking 3 steps on the response 2 and 3.
Expire. And a separate I has been filed and along with a contribution which is numbered as ISC 48 of 2024.
45.
Oh, sorry, 45 of 2024.
And I will allow take step in this case.
If you press take press steps on respondent number considering complete requirements of each to press steps on respondent number 2 and 3. Arrow and in IA 45 should notice.
Others will no need. Others no need is now. Only after service of notice this will come.
Only matters will be tested after 4.
Well,
You take steps for 1, 2, and 3 there, and in
one,
4
two,
other
two,
one also
no,
you take.
2 and 3 and we are 4 separately.
4 already expired. So how
Expired.
can you issue notice to 4?
Legally yes.
Oh.
Substitution
Yes,
petition,
substitution.
my lord.
Yeah,
For
you have
delay-
already filed your substitution
Yeah,
petition.
yes, my lord.
Yes, you can file. Issue notice to the all those.
All this legally.
Obvious, my lord.
May it please your lordship, there has been a delay of 82 days in preparing the application. Your lordship may first time it has listed, your lordship may good note.
Pardon me, not the that's applicant. This is an application under the 5 of the Limited Act for contradicting the delay of 52 days with the application under section 151 of CPC for restoration of application. Application file I bracket of C 3573 of 2020 on 26/4. It's a then appears for the court for the applicant. This is the court. This is the court approval.
May I please your lordship? Lordship, as per office note dated 2/4/24, lordship, respondent number 2349 file Wakalatnama, lordship, and 1578 service is complete, lordship. But regarding
File Wakalatnama
2349
2349.
Yes, lordship. And regarding respondent number 1578 service is complete, lordship.
1578
lordship.
and 6 is remaining.
6 is address is not found. So may I pray you, lordship, take first step upon respondent number 6, lordship.
Mr. Peter and as per office note dated 4/2024, the Wakalatnama has been filed on behalf of respondent number 4 and 9, and service is also completed on the phone number 1578. However, the notice did not answer for the respondent number 6 with a note that address is not found on given. Press number 6 to raise the queue. To try to collect proper address also.
Yes, lordship.
Correct? Proper. this record.
May it pleases your lordship. Lordship, matter may pass over for the day. The conducting council is having some difficulty today, lordship.
Who is your conducting council?
Mr. S.P. Chaudhary.
Day after tomorrow, what? When do they want?
It can be fixed on Monday, lordship.
Monday already listed out. Monday list is already out. It may
Lord,
be on
you
the
will be out of station from 1st of May to 7th of May.
1st of May.
1st of May to 7th of May, he will be out of station. So after 7th of May, matter may be fixed.
Either maybe after 7th of
After
May or
7th.
prior to 1st of May.
Yes, Lord.
Monday. 30, Monday. 30. He'll be out of station after 7.
Yes, Lord.
After 7 can pick it.
Yes, you are. क्यों अभी आई है ना नहीं पता अभी क्यों
75 day. Okay. This recording.
17.5.
Yes, 7.
Much of it.
Deeply.
40 and 41 lordship. Dismissed for lordship non-prosecution. I have skipped the matter because lordship, my name was not shown in the cause list. Lordship will have the cause list at page 27.
In which item?
In 40 and 41, same lordship.
Okay.
It was last listed on 26th of February lordship, but my name was lordship not shown in the cause list. So lordship, I have skipped the matter. Page 26 lordship, the cause list. And page 27 is the item. Item number 9 and 10. Lordship may recall the order, Lordship. LA appeal.
9 and 10.
9 and 10, yes, sir.
Your name was not shown.
Not shown, Lordship. Though I was engaged, Lordship.
Lords. So it was earlier dismissed. Dismissed on 4/11/22 earlier,
Yes.
Lordship. Then
Earlier?
yes, Lordship. Then it was restored on 7/8/2023.
And again it.
Again,
Because
same set of council,
yes,
set
no.
of council, Lordship.
Earlier,
and
earlier also A. Sharma was there. So Lordship, when the Lordship, he did not pursue the case properly, Lordship, and it was dismissed for default. So Lordship, the petitioner Lordship engaged us, Lordship. Accordingly, Lordship, we have filed restoration petition, and accordingly it was allowed. After Lordship, this petition being allowed, we were waiting for a hearing. So matter was not listed. Then Lordship, we have preferred an early hearing petition. Lordship, we filed the early hearing petition, also have annex. When the early hearing, despite Lordship filing early hearing petition, the matter was not listed. Then we entered in the registry. Why the matter is not coming despite early hearing petition? Then it was learned that Lordship on 26th February it was listed. But Lordship, unfortunately, my name was not in the court. So that's a small issue, Lordship, that can be considered.
They have filed earlier hearing petition
Yes.
after dismissal the order. The same set of council, Lords. They did not enclose the restoration order.
I have mentioned, Lordship. Specifically mentioned, Lordship.
Again, Lordship, I like to point out one thing, Lordship.
If they have their objection,
There are
Lordship,
delay, 38 days delay, without condoning petition, they have filed a restoration petition, Lordship.
No,
There's a delay
no,
of
Lordship, no.
Lordship.
It was filed
Lordship.
immediately. No delay is there, Lordship.
As per 122 of the Article of Limitation Act, the limitation period is 30 days, Lordship. But it is 38 days already.
Lordship, it was filed on 23rd of March. Lordship will see the
No,
affidavit.
no, Lordship.
Affidavit, Lordship, is there.
Please peruse the record, Lordship.
We have filed in time, Lordship.
They have filed 5/4/2024, Lordship.
Lordship, it was filed on 25th. Affidavit is there, Lordship.
Up to this court, Lordship. I just like to point out the matter. Limitation is there.
Have there been any limitation of issue, Lordship? Definitely, it has been under Lordship in objection, under objection. It was filed in time, Lordship. Might be, Lordship, my line of friend has seen some other order, Lordship. Had there been any delay, Lordship, registry would not have been
They have
Lordship,
signed in
registered a
affidavit
case.
2000. They have signed in affidavit, Lordship,
Yes.
20th March.
Yes, it was filed also.
But it was filed on 5th of April 2024. Already 8 days delay, Lordship.
No delay, Lordship. Lordship, you see the record, Lordship. It was filed in time, Lordship.
No, as per
Oh, Lordship, one
very
issue is there. Lordship, one issue is there, Lordship. Lordship may have the page 9. That is issue is there. My learned friend has also not seen that.
Yes,
For the certified copy, Lordship, we have applied on 20th of March. And it was delivered on 1st of April. So, Lordship, we have definitely get 10 days, 11 days we will get, Lordship. That delay, that perhaps Lordship, it was not counted by my learned friend.
Lordship, is this count on the date of the
Yes.
dismissal, Lordship?
No, date of the
This is
dismissal is
the
different
Limitation
issue.
Act, Lordship. Article 122. To restore a
Lordship,
suit.
my learned friend is not getting the point, my point. My issue is that, Lordship, it was dismissed on 26th of February, it's fine. We have applied for a certified copy on 20th of March, within the time. But certified copy was provided on 1st of April. So Lordship knows the provision. If I applied for the certified copy and it was Lordship submitted or it was provided to the person, there is a delay. The delay will be Lordship entitled for this petition, entitled for the, that there is Lordship. So 11 days we will get Lordship. From the date of file, submitting our application for certified copy to delivering the certified copy. That 11 days we will get Lordship. So even assuming it was filed on 5th, Lordship, there are 4 days more, Lordship.
No.
दादा आपने बुझे बनाए थे
No. Lordship.
आपने बुझे बनाए ट्राई करो ना बुझा करना
To restore-
तो कम ये पीरियड कर हम कोई भी मार्क्स को
Date of the dismissal.
आपको बुझे तो
It's up to the Lordship. I just like to
My
point
last
out the
point.
issue. Article 122
that is
of
there,
the
Lordship.
Limitation Act.
I am not denying that point. My submission is that,
It is up to
Lordship,
the court.
since we have applied the
It is
certified
dismissal
copy,
twice, for
that
non-prosecution
is
of the
there. We
counsel,
have not
Lordship.
suppressed. We have mentioned in this petition. The issue is, Lordship, I am clear, Lordship. We have applied for certified copy on 20th of March. So 20th of March is,
You
Lordship.
want to say regarding the computing of the
Yes, registry has seen that.
11.
Yes, registry has seen it. Definitely, there will be nothing, Lordship, in Lordship regarding registration. Sections, nothing will be there, Lordship, if there is delay. That 11 days we will get, Lordship. So from 36 to up to, Lordship, up to 7th of April, Lordship, there is time. Certificate to be applied.
Okay, this is for the delay continuation. And rest apart, do you have any objection in restoring the
Lordship.
have you objection?
Lordship, I have.
You want to file any objection here?
Lordship, definitely, Lordship.
It will just delay the proceeding, Lordship. Let them file objection, Lordship. Not. It will just delay the process, Lordship. Nothing will be happening. Land acquisition, Lordship, we are selling the quantum of, Lordship, land acquired of us.
Only on delay matter we have.
Delay, Lordship,
we have
Lordship, point is
point out.
clear. My learned point is not getting the point.
I point out only on delay matter, Lordship. It is earlier twice it is a separate thing, Lordship. Only on delay matter I would like to point out.
Lordship may give me 2
In
minutes
that
time.
context, you want to file any objection? That's what I'm saying.
Lordship, 2 minutes time. I'll point out the provision, Lordship.
No, provision I know.
Yes.
Now,
There is no issue,
So
Lordship.
the question is that regarding the allowing of these two petitions, do you have any objection?
Lordship. Okay. Up to the court, Lordship.
Now the question is that most of the delay, the time is also computed by the registry.
Lordship.
And it seems that the 26th to the order was passed.
Yes.
Dismissal order was passed.
Lordship.
And in that case, up to 2nd of April, most of it is the time
Lordship.
for filing it within, if it is to be within up to 2nd of April or up to March 20th.
Lord.
2nd of April. But the question is that the 11 days was taken in the
certificate
certificate copy Most that has also been calculated by the IAF.
No,
So
that
there
will
is a
get
no
lodged.
note in regarding the delay of the matter.
Lordship.
So thereafter also, if you want to submit anything, in that case, you can file objection.
Don't have objection.
So in both the matters, what was
Both the same lordship, same order,
same order?
lordship.
Two orders are there.
Two orders are there.
Similar matter.
Similar matter.
Similar. Available 8 and 9.
Yes. Section 12. Section 12 should have open.
It is. It is.
And where you have filed your early hearing petition? Do you have annexed it?
No, the next lordship.
Early hearing petition starting from page 5. lordship.
5.
Sorry, lordship, page 15.
Page 15?
Yes.
In main case?
No,
Where?
lordship, in this application.
Page 15 is different thing.
Page 15, 16. lordship. Starting from page 14, second slip. And page 15.
Oh, yes. From page 16, the application is there.
And section 12 will come, lordship. Section 12 of limitation rate will come, lordship, regarding the time consumed in getting the copy.
Okay.
Because the copy होना चाहिए था अपना देख ले बाकी ने अपने लगी
That 40, 41 can be disposed of?
Lordship.
We are going to discuss.
Lordship will direct the registry to reflect my name since my appointment my jail in the main case. I'm deeply obliged.
Master.
40, 41.
Yeah, please, Your Lordship. Here in this case, we are on behalf of the railway and we have filed an early hearing petition. Your Lordship, here the matter is that we have also filed the counter affidavit yesterday. It has not been got tagged yet with the file, so matter may be fixed for hearing, Your Lordship.
Lordship, I haven't received the copy of the IA in this case for the petition.
IA and counter affidavit also we have filed.
Yesterday I have received the
Counter affidavit.
but I haven't received the copy of the IA 561.
We have filed.
51.
See, it's okay. I is for early hearing
Early
only,
hearing,
I think.
yes,
If
yes.
you fix the matter for hearing, suppose within a short period, it's okay.
Yes.
The counter affidavit file, you file counter affidavit.
Yes,
with
yesterday
the
only.
I also. I.
No, Your Lordship,
No,
in the main appeal. Yes, Your Lordship.
Main appeal.
LC has already been received.
Then it can be fixed for hearing.
Yes, Your Lordship.
I may be disposed of, and we will.
A date may be fixed, Your Lordship, so that
My name may be shown, Your Lordship. Although my name is Jer, my senior counsel U Chakraborty is led by this case.
40, 42, no? Hard MS.
Your Lordship, I am appearing on behalf of U Chakraborty, ma'am, M Chatterjee.
You are M. Chatterjee.
Yes, Your Lordship.
Hard MS M. Chatterjee. So, the early hearing petition was filed by you only.
Yes, Your Lordship. By the Railway Union of India.
Chatterjee, appearing on behalf of MS. U. Chakraborty for the also Mr. You also appearing.
And everything.
I also heard Mr. P. Kogut appearing on behalf of the appellants that applicant. We are for railway, na? Thank you. You are Mr.
Arpal.
Arpon. You are for the appearing on
Appellant.
you are for the appellant. In fact, you are the appellant.
Yes, sir.
अच्छा. Response appellant को I could pull down. Pass the order into I. Submitted by so you are the appellant in fact.
Yes.
But Your Lordship, before early hearing, the railways they have filed the
IA.
IA has been filed.
No, yes. Fair enough. You are Mr. R. Paul.
Yes. Okay, appellant.
So your name is not there. That's what I. Is your name is reflected? No.
Yes.
So you are appearing on behalf of someone or
Yes, yes, Your Lordship. I am
A.
appearing on
Chaudhary.
behalf of.
A. Chaudhary or
A.
what? Huh?
Yes.
MS A. Chaudhary. And submitted that you not receive the copy of the present copy of the petition of the present I, which is filed under section 151 of CPC for early hearing and disposal of the appeal number application appeal number 4 under section 27(1) on State Arbitration Act, Arbitration and Conciliation Act 1996. However, it is not MS Chatterjee, the also appearing on behalf of the Union of India, has submitted that they have already filed their affidavit,
Counter
affidavit in the arbitration appeal 15 of LCA has already been received.
Yes, Your Lordship.
LCA has already been for so for the early hearing, you don't have any objection.
No, Your Lord.
But in the for the present IS it is also directed to reflect the name of Mr. Gopal. The present PHP. I'm fixing the date. We photo. The present photo. Now come to our arbitration. Airport. The running to the payment of MSP and also part MS and deputy appearing on behalf of MS Kumar Google for the respondent that let's break with Elshire has already received. The counter affidavit, copy of counter affidavit.
Yes, we have received yesterday.
It is also submitted for that counter affidavit, copy of the counter affidavit. Matter may be reported for it. Yes, any your favorable date, any?
Your Lordship, on 30th May
30. Next month. Yes, 30. List according to my 30th of May. And the STV is also directed to the Mr. Google.
Obliged, Your Lordship.
May please, Lordship.
I dispose of
May please, Lordship. My simple prayer is to withdraw this IA number 773 2024. Due to some typographical mistake, I am filed the withdrawal of the petition with a liberty to file again the stay vacating petition.
773.
The last
is not there. 733 is there.
733. Now I am going to do. I am praying for withdrawal this IA.
with the liberty. What happened? Stay order is continuing last 7 years. I am respondent number 1 in the it's a CRP. I am victimized. There is some typographical mistake. I am going to withdraw this petition. Nothing more else.
So this I is for withdrawal of?
Or 773.
The 733 is a withdrawal petition.
No, withdrawal petition is 1067. First. Actually, stay vacating petition. I have seen some typographical mistake. Hurriedly filed the case.
So you want to withdraw 733?
733.
So for that reason, you have filed the I of 1067.
Yes.
For withdrawal.
Yes, ma'am.
Do you have any objection in
I
withdrawing?
don't have any. I have not received any copy of any new IA file. I have the copy of IA 73324, but any new copy, IA if any has been filed, I don't have any knowledge about it because I have not been furnished with any copy.
Your Lordship, I have already furnished the copies of IA number 773.
So that
withdrawal petition copy is not. This is the withdrawal petition.
Withdrawal petition is there, but you have filed your that you need a liberty to file.
Liberty to file.
That's why most probably they should get a copy. Otherwise, it's okay. No reason is there. But the question is that you are, apart from the withdrawal, you have prayer for filing a prayer to liberty to file it.
Liberty.
So that's why. If do you have any objection? It's not there. So there were some typographical mistakes.
Or nothing more else. What I hurriedly filed this case? So, mistake.
Don't file it hurriedly. Anyway. So we are on 1067. 10 IA1. So Mr. M. Tarukar. Mr. M. Tarukar. And also heard Mr.
G. Kaushik.
G. Kaushik. It is an application for withdrawal of 7 2024 by the connected with PRP number PRP bracket of I number 311 2019 due to some typographical in this context, Mr. Boss did not submitted has not submitted copy of it, however, has no objection in withdrawing the IA civil number 733 on the date submitted with the present IA. If the present application allows for withdrawal of IA number 733 at 5 of fresh because you know I have to with the above of the present I. Now, if 1067 is disposed of, suppose, then 733 is also disposed of. This will be disposed on withdrawal. It will dispose of 1067 and now also dispose 733. 733 for hardware practice. In view of the order passed in IA civil number 1067, the present petition stands disposed of.
Lordship, on the last date, the Honorable Court had directed us to take steps on respondent 3 and 4 as per the office note dated 24.
In main case,
In the main CRP.
Main CRP. So in main CRP, you are the for the
I'm for the petitioner.
Okay.
So the notices have come unserved for respondent 3 and 4. Lordship, and I don't have any other new address for them because I have procured the address from the title suit which has been filed by the respondent number 1 only.
So he can help you otherwise.
Yes.
Can you?
My learned friend may help me to
Yes.
if there is any new address.
So he is basically appearing in for whom?
For
in the main
the plaintiff, original switch plaintiff.
No, whatever in main CRP you are appearing for respondent number 1.
Respondent number 1.
Respondent number 1. So he is facing problem for respondent number
3 and 4.
3 and 4. 2 is already served. So 3 and 4, if you have any address or you can help us collecting the new and proper address if you have any. Do you have? I mean, just I'll tell you the names. Now see, 3 and 4 are Sri Sitaram Burman, son of Bhavesh Burman, and Sri Sashikanta Mahanti, son of late Pitambar Mahanti. Do you have any address?
I have also no knowledge about this. Where about the if necessary, they publish in the newspaper.
In all the cases, possibly they are all resident of Rukmini Gaon.
Yeah, similar address. Respondent 2, 3, and 4 are of the same address.
Yes. No, even one also.
Even one
of,
also.
This is the address they have procured from the main case. So they do not have any other alternative to procure any other new address, in fact. So they are the necessary parties and the resident of the same locality, in fact. So what to say? Do you want any sort of accommodation you can consult with them? Because the Rukmini Gaon is the address.
Yes, sir.
So in all the matters. So they may know also. If you know the address or if you know the person,
then I help them.
Because in per office note it has returned answer, address is left. If you positive, it is permanent address, then okay, we'll try once. Otherwise, we have to go for the paper publication. Dusty will not help you, I think.
Yes.
But it means CRP. Hard Mr. or the council for the petition on the hard and it is as per office note dated 23/4/2024. The answer notice received back for the response number 3 and 4. Inverted comma address is left, architect. Inverted comma. According to the it is also from the addresses given to the that addresses given to the suit as well as in the present petition, it seems that 3 and 4 also belong to the same locality, and they are also shown to be the resident of Rukmini Gaon, Teltola, Goa. The address of the respondent number 1, 3, and 4 are same, and hence the Senate Council for the evidence is hereby asked to proper and present address if any for the respondent number 3 and 4, and that is not Mr. M. Beyond that the petitioner side. you need 3 weeks minimum time. Just one more try. If it is not possible, then definitely. And you also try to accommodate the other side because they are from the same area, in fact, the Rukmini Gaon. So they may be there, or your respondent may know the address of this house. That's right. Okay. So your other two petitions are
May it please your lordship. Lordship, we have tried to contact the insurance company advocate, but we are unable to do so because the earlier engaged counsel has left the insurance company cases and he has went to Delhi.
It is a case of insurance company.
No, I am for the owner of the vehicle and I am the appellant, but the respondent party insurance company was not appearing. So we were advised to contact the
respondent insurance company is
National Insurance.
National Insurance. Manu আমার খুব মানুষ আছে প্যানেল whom you have there may be other panel advocates. It is not our part, but the question is that they should take the report. Otherwise, insurance company is a necessary party.
Yes,
so if no one has represented the respondent insurance company, it will be difficult on your part also. So just do one thing. If he has already contacted Mr. Purkaister, the panel
Yes,
advocate,
I have also contacted him.
but he is no more in company, I think.
Yes, Lordship.
So other panel advocates may be there. Because National Officers Company cannot be there without any
Yes,
panel
Lordship.
advocates the company will run. So definitely there may be some advocates, panel advocates are there, still there. So you can do one thing, otherwise what can we suggest? Because earlier to be there were Mr. Purkaister was also there. And for one, Mr. P. Problematic. Yes, tell us what to do now then. You have to take initiative, otherwise, from our side also, he had made already contact with Mr. Purkaister. But
we can take steps as one of the options, Lordship.
Yes, you can take steps. This is one of the options because if company receives the notice, they may engage someone. We cannot insist anyone to take the case. To take fresh steps on response number, he is the response number 2.
Yes, Lordship.
Your branch manager, National Insurance Company is response number 2, na?
Yes, sir.
Hard MSK Pora. The learned counsel for the students case is before hearing. It's submitted by her that she made a contact to be given as to who can get counsel. Sorry, this one number 2. But was submitted to counsel and does this case on this one. That's it. 40K report. 40K the stability limited invested on as on the of the company page and the panel has cases of the pending since 2008 considered the steps and to do not to press it's accordingly to pay the conflict and also take steps for the
Obliged, Your Lordship.
May I please, Your Lordship? Here, my Lord, I am appearing on behalf of D. Soikia, Learned Advocate General Assam, my Lord, also the senior advocate in this matter. Now, here, my Lord, the issue which is with regard to rejection, my Lord, of an amendment application that was filed by the defendant, my Lord, in the trial in the suit, my Lord, down below. If Lordship may be pleased to come to page 23 of the civil division application. Page 23 is the plain.
Page 23.
23, my Lord. Lordship will see this is the plain. This is practically a money suit. There, my Lord, will find, my Lord, the plaintiff is Sri Jacob Nazari. Now, Jacob Nazari here, my Lord, he is the respondent number 1. And who are the defendants, if my Lord may be pleased to see? The defendant number 1 is the state of Assam, represented by Commissioner Secretary, Finance Department. Then defendant number 2, Boroland Territorial Region, BTR. Defendant 3, my Lord, the Council of Head of Department Irrigation. Executive Engineer is the defendant number 4. Now, my Lord, the claim of the plaintiff down below, that Lordship will find, my Lord, at page 26, the prayer portion in the plain. The plaintiff therefore prays for a decree for recovery of the suit amount of rupees 50 lakhs 18,524, then also, my Lord, interest and other relics. Now, the whole basis for filing this money suit is, my Lord, the work order that was issued, my Lord, to the defendant by the authorities of, my Lord, the Boroland Territorial Council. That work order, Lordship will find at page 27. This is the work order. Now, what was the work to be done, my Lord? The work order, if Lordship is taking up page 27, Lordship will kindly see, my Lord, subject. It is addressed, my Lord, to Jacob Nazari, that is the plaintiff. Subject, Ratikola Flow Irrigation Scheme, lining of branch canal from so-and-so and improvement of efflux band, etc. under TSP so-and-so. So this is the work order. Then, if Lordship turns the next page, Lordship will find the written statement filed by the BTC authorities, the Boroland Territorial Council authorities. That is, my Lord, the defendant number 2, 3, and 4. The written statement starts from page 28, Annex 3. Page 28, my Lord, it is an exhaustive written statement. Here, my Lord, the claim and the statements and averments made in the plaint, my Lord, that has been, my Lord, disputed and denied, my Lord, by the BTC authorities. That is the, my Lord, the defendants. If Lordship may be pleased to come to page 30, that is, my Lord, paragraph 12 of the written statement. Paragraph 12 of the written statement. I am just reading it quickly, my Lord. So far as the averments and contentions made in paragraph so-and-so of the plain, it is submitted that according to the terms and conditions of work order issued so-and-so by the defendant number 3, it appears that the plaintiff was asked to start the work within 7 days from the date of issue of the said work order and was to complete the work within 12 months from the date of issue. But the plaintiff, in spite of clear terms and conditions stipulated in the work order, failed to complete the work within 12 months and filed a present suit on the basis of first running bill, and that too without completing the work as per direction and terms and conditions of the work order issued in reference to the NIT, so the plaintiff's suit is premature. Then, my lord, all the running bills and, my lord, with regard to all the facts have been disputed. Now, here what is more important is that, my lord, Lordship will kindly see, my lord, at page 31, my lord, the third paragraph. It is submitted that the first running bill dated so was prepared, but due to some irregularities in the work done and non-availability of fund, the same was not released. However, during careful scrutiny and verification, it was detected. Now, this is important. Some officials of the department had involved with malpractice, and consequent whereof the process of NIT was started and the work order was issued to the contractor, including the plaintiff. On detection of such malpractices of some of the officials of the department, the defendant number 3 at the direction of higher authority lodged an FIR under memo number so-and-so to the officer in charge, Kokrajhar Police Station, and who started the investigation. Now, copy of the FIRs, my lord, everything was annexed, were annexed, my lord, to the written statement. That, my lord, will find at page 32. At paragraph 13 of the written statement, my lord, will find at page 32 that subsequent to filing of FIR and starting investigation, the matter was taken up by the Chief Minister's Special Vigilance Cell Assam for detailed inquiry, and as per direction of the inquiry officer, Chief Minister's Special Vigilance Cell, the entire record, all the files of the subject matter present suit has been furnished, submitted to the Deputy Superintendent of Police, Chief Minister's Vigilance Cell. Then, my lord, the BTC authority had issued a general order whereby, my lord, all the work orders that were issued, my lord, has been put to halt. That, my lord, will find at paragraph 14 at page 32 itself. Now, my lord, under these conditions, my lord, where several illegalities were detected, finally, my lord, during the pendency of the suit, my lord, down below, WS was filed, my lord, now the case was fixed, my lord, was pending for framing of issue. At that stage, my lord, the defendants came to, my lord, have the occasion to get hold of the letter dated 8/10/2020. That, my lord, will find at Annexure 5, page 42. Annexure 5 at page 42. Now, here, my lord, all the detailed allegations has been made. Now, that work order was issued, my lord, in pursuance of guidelines and direction issued by the, my lord, central government, that is the Union of India. But here, my lord, on perusal of this letter, lordship will find that no such, my lord, government order of the central government existed, and it was a fake order. So, we had taken the ground of fraud, that the plaintiff has committed fraud by filing this suit, and the materials which were annexed to the plaint, my lord, are all fraudulent materials. So, under that circumstances, my lord, an amendment application was filed. That amendment application, lordship will find that amendment application, lordship will find at page 47, Annexure 9. Because issues have not yet been, my lord, framed. So, prior to filing of the issues, my lord, as mandated under the provisions of, my lord, Order 6, Rule 17 of the Code of Civil Procedure, my lord, this amendment application was filed. And this amendment application, my lord, was filed, my lord, on, my lord, in the year 2023. Precisely, my lord, on, my lord, 29th of June 2023. Now, here, my lord, the difficulty has arisen. While drafting this amendment application, lordship will find, if lordship may be pleased to come, my lord, to page 51. In the amendment application, all the background that led, my lord, to, my lord, the practice of fraudulent practice, everything was stated. Now, what was exactly sought to be amended, that was precisely not, my lord, put in the amendment application by the drafting council. the foundation was laid, my lord, in the amendment application, but what is exactly to be amended, that was, my lord, skipped out. I have to make a fair submission before this honorable court. What is there on record? And if lordship may be pleased to come to page 51, running page 51, my lord, that is a part of that amendment application. I will draw my lord's attention, my lord, to paragraph 6, 7, and 8 of the amendment application. Paragraph 6, 7, and 8 of the amendment application that lordship will find at page 51. Now, at paragraph 6, my lord, it has been stated that in such situation and circumstances, the defendant number 2, 3, and 4 to protect their interests and the interest of Bodoland Territorial Council are to amend the written statement filed by the defendants incorporating the facts which may level in changed circumstances. The defendants beg to state that few new facts come up before defendants that original sanction order purported to have been issued by the Government of India for payment of contractual bills under special central assistance to tribal plain so-and-so are fake and does not exist at all. And as such, any subsequent action on the basis of such fake documents cannot be sustained legally. Then at paragraph 8, it has been stated that since the original sanction order as fake and non-existent, so no court can grant any relief on the basis of such fake documents, and as such, the BTC cannot be held responsible for making payment to the contractor plaintiff for the contractual work done on the basis of such fake orders. If at all any liability is to be fastened, the same should be directed to the official individually and personally who had issued the contract orders on the basis of such fake documents. Lordship has seen this. Now here, my lord, the amendment application is not that happily worded. It has, my lord, failed, my lord, to meet the technical parameters. If I am to amend the plain or the written statement, I am to state in clear words that these are the things in quotation, that after paragraph so and so or within paragraph this is to be inserted, this is to be substituted. Now this amendment application was not drafted in that manner, my lord. Now under that circumstances, my lord, against the amendment application they had filed a written objection, the plaintiff, and finally the learned trial court has passed an order thereby rejecting the amendment application, against which we are before, my lord. That trial court order, lordship will find at page 57. That trial court order, page 57. It starts from page 57. The background of the case has been discussed. And finally, their objection has also been discussed. And the learned trial court below, my lord, had also relied on a decision of the Honorable Apex Court, my lord, while rejecting, my lord, the prayer for amendment. And finally, the operative portion, lordship will find at, my lord, page 70 onwards. Page 70, if lordship is taking up page 70, that is a part of the, my lord, order put to challenge here. I am reading it, my lord. The last paragraph, my lord, paragraph number 3 at page 70. Here in this case, in absence of any proposed amendment, the grounds shown by the defendants are not sufficient to allow any amendment in the written statement, as there is no new facts or changed circumstances which needs to be introduced before the court. So the court was also handicapped, because since the particulars were not pleaded in specific in the amendment application. Rather, the amendment may divest the opposite party of an advantage which it has secured as a result of an admission by the party seeking amendment. Secondly, amendments sought by the petitioners on the ground of original sanction order issued by the Government of India are fake and does not exist, is not necessary for the purpose of determining real controversy between the parties, as the petitioners have already pointed out the detection of malpractice by their official in their written statement and admitted the work done by the plaintiff. The plaintiff should not be a victim for the malpractice of their official if otherwise acted bona fidely. The amendment may cause injustice to the other side as it seeks to withdraw clear admission made by the petitioner in the earlier pleading. In view of the discussion made above, the prayer of the petitioners is stand rejected. Accordingly, case is disposed of without cost. Now, in this situation, my lord, at this stage, my humble submission will be, my lord, if lordship takes up the provisions, my lord, of course, keeping in mind, my lord, that the amendment application has to be specific. If lordship is taking up, my lord, the provisions of Order 6, Rule 17, the CPC, I am reading it, my lord, because issues has not been settled. Issue is yet to be settled. So we have filed the amendment application at the earliest possible opportunity. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial, so this will not be applicable. So my submission will be, my lord, yes, it is true, my lord, that this amendment application was not happily worded and it was not, my lord, technically sound to that extent, my lord. But nonetheless, my lord, there are some findings, my lord, in the impugned order passed, where, my lord, the learned trial court has commented on merits. Now, those findings will be, my lord, detrimental to the parties, my lord, of course, to the defendants during the trial. So, to that extent, my humble submission will be, my lord, lordship may be pleased, my lord, to interfere with this, my lord, impugned order, so far as, my lord, the observations on merits, my lord, commented by the learned trial court below. Because what is there on record, my lord, I cannot make any, my lord, deviating submissions before this honorable court. So therefore, this is my respectful submission at this stage. Because admittedly, my lord, I cannot travel beyond the provisions of law, and this amendment application was not at all happily worded. That I must, my lord, admit. I have to be fair to the court. But nonetheless, my lord, the observations that, my lord, at paragraph at page 70 and in other places, my lord, of that impugned order, whereby, my lord, the learned trial court below has commented on the merits of the case, my lord, that will, my lord, that some clarification from this honorable court is required to that extent. I am seeking an interference only to that limited extent. The learned trial court below has come to the finding that we have made admissions. There are clear admissions. Now, my lord, evidence has not yet started. We do not know what issues will be framed. It is at the very, my lord, prior stage. Trial has not yet commenced. Lordship is well aware, my lord, that the trial of a civil suit commences upon framing of issues. Issues has not been framed. Now, at this stage, my lord, if the learned trial court makes observations, my lord, detailed observations, my lord, on a miscellaneous proceeding, my lord, like, my lord, this one, the amendment application, my defense will be prejudiced, my lord, because they will come up and say that no, at that point of time, the learned trial court has made that, because my witnesses will be put to cross-examine. Kindly see, this is the order. Do you admit? This kind of questions will come. But that will prejudice me. Only to that limited extent, man. This is my humble submission.
May I please look? You can hear your part after.
There is a small prayer. Out of this action, your lordship, altogether 20 cases has been filed, out of which 18 cases are listed today before Honorable Justice Devashish Barua in court number 17. Two different views are taken by the coordinate bench. It will be difficult.
Yes, some cases are also listed there. So lordship may be pleased, my lord, to lordship may be pleased to hear the parties and reserve the order. And if in the meantime, my
yes, then it will be
yes
difficult.
Because otherwise,
There may be the opinion may be different.
yeah, opinion may be different. Opinion may be different. So otherwise, if Lordship may be pleased to post these matters, my Lord, on the next week, subject to outcome of my Lord the
Yeah,
senior bench.
the other matters have already, I mean, that is already disposed of, or
No,
also, I mean, it is still.
Listed today. It has not; those matters have not yet reached. It will be taken up perhaps, my Lord, in the second half. Second half. So if Lordship may be pleased to, my Lord, adjourn this matter, my Lord, for another 1 week, next week. By this time, my Lord, today if some final order is passed, we can place those orders before my Lord. Lordship may also pass similar orders.
So is there any way to place this matter also before?
No, today it will not be possible. Today it will not be possible. So therefore, under those circumstances, if my Lord may be pleased to fix this, because he had filed, my Lord, altogether 20 number of money suits down below, and in all the money suits we have filed, my Lord, amendment applications. So there are 20 impugn orders, and against the 20 impugn orders we have filed 20 numbers of civil division applications before this honorable court. Out of 20, my Lord, 2 are listed before your Lordship today, my Lord. 1 is such matter, and the rest 18 numbers are listed today, my Lord, before court number 17. So under those circumstances, if your Lordship may be pleased, my Lord, Lordship may fix this matter, these 2 matters, my Lord.
So in that case, it will remain as a part heard, or what? If it is a part heard, then
Yes,
suppose,
Lordship can keep it. Lordship can keep it.
So the next week, because our roster is also uncertain.
Yeah.
So till third.
No, Lordship may not keep this as part heard. Lordship may not keep this as part heard.
We will not
post it after 1 week.
After 1 week.
We can post it after.
Yes, yes.
If it comes before this court, it's okay then?
My Lord. Because on marriage, my Lord, I have a weakness. I cannot forcefully submit, my Lord. I have to be fair to the court. This is my difficulty. Your Lordship can post it, my Lord, on my Lord.
The 46 also same?
46, 45, 46. Lordship can keep it on the next week by fixing a date, my Lord, if my Lord may be pleased to do so, my Lord. It can come on, my Lord, on the 9th of, my Lord, May, or prior to that, my Lord, on...
No, not prior. Let it be on 9th or let it be on 10th?
10th.
Because
my Lord, my Lord. Then, my Lord, Lordship can fix this matter, yeah, on 9th, my Lord. 9 will be a my Lord, hearing day. 9th or 10, any date, my Lord, subject to the convenience of the court.
9th is hearing day.
No. 10
So I have to record any part heard.
My Lord.
It will be listed on there.
My Lord.
Hard friends for going to put it on. Okay, we'll list it.
I'm so obliged, my Lord.
If I'm be here till 10, then matter may be hard.
Lots.
Okay. However, I have noted down your submission.
My Lord. I'm so obliged.
For judgment pertaining to Itanagar bench, criminal 9 of 18.
The appeal stands dismissed. Am I audible? Appeal stands dismissed.
Okay.
And the order passed by the judgment and order passed by the learned court below is affirmed. And this sentence is also found to be reasonable and justified according to this calculation. The represent of census and petitioner is directed to pay maintenance zero of the farmer. Petitioner has directed earlier and also directed to pay any adjournment. Item 48, the primary represent